Hello, everyone. I'm Justin Silverman with the New England First Amendment Coalition. Thank you for joining us for this latest open government lesson. For those joining us for the first time, welcome. These lessons are a part of a growing NEFAC library of classes on public records, open meetings, court access, and our right to record. All lessons are available to view in our FOI guide or on our YouTube channel, 5 Freedoms. To everyone, please take a moment to subscribe to NEFAC's community newsletter. This is the best way to stay informed about upcoming classes and events. Just go to nefac.org/subscribe. Today's presentation is supported in part by the estate of Gloria L. Negri. Gloria was a trailblazing journalist at the Boston Globe for more than 50 years. This program is part of her legacy of newsroom education and her lifelong commitment to local journalism. You can learn more about Gloria and other NEFAC supporters at nefac.org/supporters. During today's presentation, I again encourage you to introduce yourself in the chat and share your own experiences and resources. You can also use the chat or the Q&A button to ask questions of our instructor, and we'll get to as many of those questions as possible. All right, let's get started. Here's Raymond Marcaccio. He's an attorney based in Rhode Island and here to tell us about our right to record. Ray, all yours.
Thank you, Justin. Hi, everybody. And thank you for asking me to speak with you with and through NEFAC, which is an incredible organization with all the hard work you're doing, especially most recently. I'm sure that most of you already know about the access rights that you have with respect to the Open Meetings Act and the Access to Public Records Act in Rhode Island. So we'll not be focusing on those. There are previous videos, seminars that speak to those rights. We're going to focus instead on a subset of that, which is your right to record, whether by photographing or video recording, audio recording, events that take place that involve government procedures. So on that first slide, Justin, we'll focus on your right to record proceedings in open meetings, public meetings. And as a general rule, any government business, particularly though that business that is performed in an open meeting session, can be recorded. You can do so both by way of video as well as by audio. And the rights that we have, while they are connected to statutory rights through the Open Meetings Act, they're not specifically set forth therein. So, but nonetheless, going back almost 40 years now, there is guidance that we have received from both the Attorney General, whose office is responsible for the enforcement of the Open Meetings Act, as well as by our courts. And if you look at, there's the right to photograph, for example, that goes back. There's an AG opinion on that goes back to 1988. And again, while the right is not specified in the Open Meetings Act, the Attorney General correctly found that that right is implicit within that statute. Likewise, our federal courts, in the case of Belcher versus Mancy, and that goes back to 1983, did find that there is a right that is implicit, again, in the Open Meetings Act to record. So those rights are longstanding and are quite broad. And I think the only time that you do have to have some concern is if there is any cognizable privacy concern with the recording of those meetings. Now, that shouldn't be the case because within the statutory structure itself, there is protection that is afforded through the right to convene an executive session. That's the burden of the government body itself, not the public. So you would never have the burden to assess that in an open meeting because that should have been properly noticed and covered under the many exceptions that we have to the Open Meetings Act for executive sessions, including discussions of matters that are relatively private in nature, such as disciplining an employee. So, Justin, we can go on to the next slide if you could. So another question that's arisen is whether or not you have some right to photograph or video the exterior of a government building. And that is permitted. You have every right to record the outside of a building, particularly if you are on government property and you're photographing a facade. I did have a case not too long ago that you might remember involving Dan Doyle. And Dan Doyle was the founder of the Institute for International Sport. And he had sued one of my clients who had recorded the outside of his building. And there were actually even images of him from as he was looking outside of his window. There were also defamation claims and false light claims in that case. But with respect to the recording itself of both himself and the building, he had claimed that that would constitute a trespass. And there was no basis for that cause of action, and the court so found, because the building itself was located at URI, which is a government-funded university, and the person taking the video was on the public grounds of that university and taking a picture of the facade itself. But that is kind of an example, a good example of how you do have rights to record on the outside of a public building. Can I have the next slide, Justin? Now, when we move from the outside of the building to the inside, there are some additional concerns, one of which we spoke about before, and that is privacy, that might arise in some cases, but also of disruption. So again, you should have the ability to record areas inside a public building, particularly those where government business is being conducted. And so long as you are not causing any kind of a disruption, both to people getting in and out, as well as to the functioning that's taking place there. So if there are government officials who are performing functions, let's say, for example, in a very, very small room, and you do come in with a camera, and there's not a lot of room to move around, I suppose they could make a colorable argument that your presence with a recording device, with a camera, could be in some way disruptive to their ability to perform their functions. Next slide, Justin. Again, part of that would be your recording of people who are performing work inside the building itself. So with respect to government officials, you do have the ability, the right, to record what is transpiring inside that governmental business, a building, when it does involve governmental business. Again, there's some longstanding case law on this. The First Circuit has found so back in 1999, First Amendment right to record government officials conducting public business in a public building. So the emphasis should be on the fact that you're recording something that is of a public nature. You're not recording something that would be private. And there may be an intersection here again where you have government officials who are speaking with citizens, for example, people who might be receiving benefits. They may be meeting with government officials, employees, to talk about whether or not they're eligible for food subsidies, heating, health benefits, anything of that nature. Now we have an intersection between the government officials who are conducting public business, and which is normally something that you can record, and someone who is coming there to discuss a government issue, but has their own privacy concerns. And there is that intersection and balancing between those two. It might even occur if you've got a student-teacher conference or a teacher's being disciplined versus something that would be purely of a public nature that the government official is speaking about. So having a recording where you are taping two officials who are speaking about something of a government nature, and it is within the government building, ordinarily should be something that you can record. Next slide, please. A government building could include a courthouse, and there are some very specific rules that apply to that group of government buildings, particularly with respect to the courtrooms themselves. And in our state, there is a set of rules that apply. It's been promulgated by our Supreme Court, Article 7 of the Supreme Court rules, that speak directly to media coverage. So having access to a judicial proceeding and being able to record it by video or by audio is something that is set forth in that rule, and it's quite specific as to what can be done. First of all, it only does apply to those people who can be considered media, people engaged in televising, broadcasting, videotaping, and or photographing. Now, in this day and age, that could be broader, but in definition. But I do think that when this regulation or this rule was promulgated, it had in mind people in news organizations. It would not, by its very nature, include sketch artists, for example, but it would be these other types of activities that are covered by media. And in Article 7, it has quite a bit of detail as to what can be allowed once the trial justice allows it to occur in the first place. So there are certain court proceedings that can be covered, others that cannot. So you could have, if you had a jury proceeding taking place, the actual case may be recorded, but the pre-hearings, the conferences, the motions that occur immediately before that are not. So that rule, that Article 7 rule is quite detailed. It even goes into the light sources, how many recording devices can be used, how many, for example, how many cameras can be used in a courtroom, typically just one. The inability to photograph jurors, that's all set forth in that rule. Bear in mind that under that rule, as I say here in quotes, the trial justice has extreme and really singular discretion as to what takes place in their courtroom. So whether or not that particular judge will permit it is left within that judge's discretion. And that is not reviewable by the presiding judge of that court. So if you were in Superior Court, there is no reviewing of that determination by the trial justice, by the presiding justice, the next level up, or the presiding judge of any court that you're in, whether it's the district court, workers' comp court, or any other. It's left to the discretion of that particular judge. I did have one case where the station, the TV station, was allowed to record all of the proceedings that were taking place in the presence of the jury. And unfortunately, the way that the camera was trained, it was trained directly on both the lawyer who's at a podium as well as the lawyer's handwritten notes. And it was visible, and some of that actually showed up in a afternoon news broadcast. You could see some of the language from those notes. And the judge, who's now retired, called in the media. I was there for that conference to chastise the media for allowing that to even happen. Now, thankfully, the judge nonetheless allowed the remaining parts of the broadcast, of the proceeding to be broadcast, to be recorded. They just had to turn away and move the camera from where it was located in the courtroom. But the point is that if that judge, especially with that having happened, if the judge had decided that at that point no further recording would be permitted, I would have had very little ability to seek any redress within the judicial system of that decision. Next slide, please. The inside of the courthouse I have listed here as being distinguished from the courtrooms themselves. And again, our rules, which govern the judges as well, indicate that no televising, photographing, or broadcasting shall take place in the courthouse corridors or any other portion of the courthouse building. So unlike, in my view, your right to be in a government building, and so long as you're not disruptive, you can record public areas within that building. Inside the courthouse, it is quite different, and that is set forth right in our rules. Next slide. The outside of the courthouse, in my view, that should be the same analysis as any other governmental building. There's nothing taking place on the outside of the judicial building that deals with the judiciary. So it is a governmental building. It is public property. So long as you're not disrupting the ingress and egress, people going outside of that building, there should be no restriction on your ability to record the outside of the building. Next slide, please, Justin. I do want to make one point, though, and that is that the rule that I mentioned to you governs all of the state courts in Rhode Island. There is a totally separate set of rules that apply to the U.S. District Court located in Providence, just across the river from the main state courthouse. And the rules there are quite different. There's a local rule on point, local rule 112, and that says that unless authorized, no person shall photograph, record, broadcast, or otherwise transmit any proceeding, event, or activity held in the courthouse. And I think that is still the case. I did have one case when I was involved in a private lawsuit and representing someone who happened to be an attorney. And during the proceedings, she was seated right next to me as a party. So she's on the other side of the bar. She's on the bar that lawyers can sit in, and she's also a party. And she was allowed to take any notes that she wanted to take. There was a bathroom break, and the judge took a recess, but my client did not come in until after the judge came back on the bench. So she was required to sit on the other side in the public part of the courtroom. She continued to take notes because she was taking notes as a party, but the marshal came over and stopped her because that particular judge did not allow any writings whatsoever in his courtroom unless you had prior authorization. That was for just a short time until another break occurred, and then obviously she was able to join me on the seated next to me, so there was no longer an issue. But and that judge is retired, and that was a fairly strict view. But under the local rules, he was allowed to do that. And there were other federal judges who also limited the ability to even write in their courtrooms. I don't think that's the case any longer. I don't think any of the current judges do that. But I mentioned that just as an example of kind of the broad authority that judges do have in governing the goings-on inside their quote. One of the last things I just want to mention, and if you go to the next slide, is whether or not you can copy or record records. And I haven't had any experience with this at all, but I would like to note that under the Access to Public Records Act, it does state that all records maintained or kept on file by any public body shall be public records, and every person or entity shall have the right to inspect and or copy those records at such reasonable time as may be determined by the custodian thereof. Now, as far as copies, there are a number of statutes that address that speak to how much you can charge per page, whether or not there's a cost for the research involved, and all of that is laid out in the statutes. But here, I just want to note that there is that language that says you have the right to inspect, which is separate and apart from the right to copy. And arguably, in my view, that if you have the right to inspect the document, for example, at that desk, at the table where it's being presented, you should have the right to take a photograph of it if you so choose. I have not had that arise in my practice. I don't know of any case where that has come up. But if it did, that would be the position I would take, that you shouldn't have to wait to make a copy. If you have it in front of you, you should be able to just take a photograph of it. And that next slide just lays out what I had just indicated to you. So those are some of the observations I've had on this question of recording.
All right. Thank you, Ray. Appreciate it.
Sure.
No questions, though there might be some questions that come up later on. What is the best way to reach you if anybody has any follow-up comments or questions for you?
Yeah, so you could just go to just send me an email, which would be if you probably don't have it there, but it's ram@om-rilaw.com, and I'd be happy to answer any questions you might have.
All right. Thank you. I appreciate that. Really grateful for your time, Ray. And many thanks to everyone who joined us today. We provide these lessons as a public service to you, so I'm asking you to please return the favor. Encourage your colleagues and friends to join us for future classes. And better yet, consider making a donation or becoming a sustaining member at nefac.org/support. Thank you again, Ray. Thank you to everyone who joined us today. On behalf of NEFAC, we'll see you next time. Take care, everybody.
Okay, take care.